An 18-year-old faces aggravated assault charges with a deadly weapon to 20 years possible. Judge Boyd sets the stage, reminding him this isn't just about law, it's about his future. Should youth earn redemption or pay in full? Stick around. This hearing takes turns you won't expect.
Here we go. Judge Boyd is about to grill an 18-year-old facing aggravated assault with a deadly weapon. That's no small charge. It carries up to 20 years in Texas. Stick around, because this one gets intense.
Captain Pollard for the state.
For the defense? And are you Mr. Henson?
Yes.
Defense, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review that with your client?
We have, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Henson, I'm showing you what's entitled Application for Deferred Adjudication.
Deferred adjudication, Texas's second chance card. No conviction if probation succeeds. But one mistake and 20 years slam back instantly. It's a gamble of freedom versus failure. For an 18-year-old, the stakes couldn't be higher. Would you risk it or fight at trial despite greater uncertainty?
Or community supervision. Did you review that document with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Henson, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with you?
The family violence finding adds lifelong weight. Firearm rights gone, custodial rights limited, future clouded. Courts know these boxes checked today ripple forever. For a teen, that's adulthood rewritten before it begins. Is this tough justice necessary protection? Or too much punishment for someone still finding himself?
Your attorney, did you understand it, and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain,
No contest, not guilty, not innocent. It sidesteps trial, avoids certain liabilities, yet still counts as conviction. To some, it looks like dodging responsibility. To others, a smart move. But here, charged with beating his stepfather. Does it show wisdom or weakness in refusing to face guilt openly?
bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Notice how the judge carefully lays out the maximum punishment, 2 to 20 years. This isn't just formality. It's the court making sure the defendant fully understands the stakes before locking in a plea deal. No surprises later.
Did you understand
Judge
by entering
Boyd
this?
doesn't hold back, no school, no job, yet demanding money. Her message is clear. If you want income, work for it. Courts aren't parents, but sometimes judges step in as life coaches. Does harsh honesty break defendants down or push them toward responsibility and growth?
Plea bargain agreement, you were giving up those rights. And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a
Blaming
factual
the
understanding?
wrong crowd, Judge Boyd isn't buying it. The crowd didn't swing fists, you did. Harsh, yes, but it forces self-reflection. Until he owns his choices, change won't come. Was the judge too severe, or did she deliver the exact reality check this teen desperately needed?
And the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Henson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's to be a $500 fine. There's an affirmative finding of deadly weapon. State recommends deferred adjudication. They will take in consideration the following county court cause numbers: 664461, 664462.
Enter the step-grandfather, offering structure curfews, chores, supervision. Judges look for support systems. They want assurance probation won't collapse. His words paint hope, but rules mean nothing without commitment. Do you believe the young man will respect his grandfather's structure, or is relapse into old habits inevitable?
71781, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of the agreement? Defense, is that the agreement?
It is, Judge.
State, is that the agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you
A 10
outside
p.m.
the
curfew. GPS tracker freedom monitored step by step. For an 18-year-old, it feels suffocating, yet it's better than prison walls. One late night, one reckless move, and probation unravels. Could you live knowing every step is recorded? Or would rebellion feel unavoidable eventually?
plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 year. There be 240 hours of community service restitution, TAP evaluation, no harmful or injurious contact with Avilio Walters Torres, that's AVILIO, no firearm possession, hostility, and aggression control course.
4
Did you
years
understand?
deferred adjudication, $500 fine, 240 service hours, anger course, employment in 30 days, unique incentives, GED cuts hours, vaccination lowers service time, Judge Boyd mixes carrot and stick. Does this personalized punishment foster growth, or merely pile conditions that risk setting him up to fail?
Those are recommendations from the state, and the court does not have to follow those recommendations. Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge. State would offer what's been marked as State's Exhibit Number 1.
No objection.
Mr. Henson, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and
Sentence
review the
delivered. Freedom under conditions. Prison waiting if he stumbles. Judge Boyd chose accountability plus redemption. Did justice serve fairness, or should punishment have been harsher? Share your thoughts below, and don't forget to like, subscribe, and follow for more gripping courtroom stories every single week.
same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, how old are you?
18.
18? So, why are you beating up your stepfather? And mind you, before you speak, I've already read the police report.
Yes, ma'am.
You need to speak up. I can't hear you.
Boom, he pleads no contest. That means he isn't admitting guilt, but he's not fighting the charges either. Basically, it lets the court treat him as guilty without the drama of a trial. Quick question for you guys. Do you think that's fair? Or is it just a legal shortcut?
I was just not in my right. I was kind of following like a lead.
I can't hear you. Open your mouth and speak so I can hear you.
Judge Boyd carefully explains the punishment 2 to 20 years plus fines. This isn't just formality, it's reality crushing down on the defendant. Imagine sitting there, realizing decades of your life could vanish. Would you still stay calm, or break under the pressure of hearing your fate so directly?
Issue, and I went about it the wrong way.
No, because I read the police report. What your issue is that you went to your mom's house where she lives with your stepfather. You asked your mom if you could stay, and you came over there early morning hours. Then you asked your mom for money, and it appears she did not want to give you money. So then you called her the B word, and then your stepfather said, don't speak to her that way. And then you proceeded to beat him up. So what was the issue? No, what was the issue? Because people, when you ask people for money, they can either say yes or no. So your mother said no. You called her the B word. Why are you calling your mom that word?
I shouldn't have done it.
No, I know you shouldn't have done it, but my question for you is, why did you?
I lost my temper,
Temper what? Because she wouldn't give you money that was her money? Is that what you lost your temper over? The fact that she said, no, I'm not giving you any money? Do you have a job? So if you want money, and this is what I don't understand about some young people, if you want money, then guess what? You get a job and you earn it. Your mom, your father, your stepfather, your brother, your cousin do not have to give you money. You're of age. Are you in school?
No.
So basically you're doing nothing with your life because you're not in school. Do you have a job?
No.
So you're not in school.